Hello and welcome. My name is Garrett Snedeker, and I am the Deputy Director of the James Wilson Institute. It's our pleasure to host you for the first of several webinars the James Wilson Institute will host at the onset of a new administration. Today, our focus is on the courts and legal challenges expected in the new Biden administration. Not only is this subject at the heart of our work at the James Wilson Institute, but we also cannot think of two better friends of our project to discuss these topics with. First, Carrie Severino is the president of the Judicial Crisis Network and co-author of the best-selling book, Justice on Trial, The Kavanaugh Confirmation, and the Future of the Supreme Court, the subject of one of our most popular podcasts in 2019. A former clerk to Justice Clarence Thomas at the Supreme Court, she has testified before Congress on constitutional questions and briefed senators on judicial nominations and regularly files briefs in high-profile Supreme Court cases. Next, Adam White is an assistant professor of law at George Mason University's Antonin Scalia Law School, where he directs the law school's C. Boyden Gray Center for the Study of the Administrative State. JWI has been a proud ongoing partner for programs with the Gray Center for several years now. Adam's also a resident scholar at the American Enterprise Institute. Previously, he practiced regulatory and constitutional law with two law firms after clerking for Judge David Sentel on the U.S. Court of Appeals for the D.C. Circuit. Now, we're going to begin our focus on the most immediate areas likely to change with the turning of administrations, on regulations. To get us started, Adam has kindly offered to set the table with some big picture themes on what we can expect with a switch in regulatory policies before we dive into some more specifics. So Adam, why don't you get us started?
I'd be pleased to. I love all the things that I've gotten to do over the years with Professor Arcus and you and the team at the James Wilson Institute. I see Hadley is up on the screen now. I don't know if he was going to get his 2 cents in ahead of time, or if I should go ahead. Okay. Well, Hadley, it's great to see you, and thanks everybody for allowing me to participate in this. Let me just lay out two basic sort of buckets of issues that are coming at us. Obviously, there's no shortage of regulatory proposals, issues, reforms, agendas that the Biden administration is going to unroll in the weeks ahead. And we can touch on those specifics as much as anybody would like to. And my guess is that on any given subject, there's going to be somebody else on the call who knows the specifics of that regulatory program more than I do. But I did want to just set the table with these few basic themes. I'll start with just the process of what's going to happen over the next few weeks. And then I want to just put on people's radars a couple of big picture themes that I'm tracking. Okay, in terms of process, my guess is this is how things are going to play out. And I feel pretty confident at this guess because it really is a refinement of what incoming administrations have done over the last several presidencies. Each new presidency, each incoming administration has learned from what's been done before. They pick up the tools that have been created by the previous administration, even an administration that they disagree with, and they use those tools towards their own preferred ends. So this is my guess at how things will play out. As soon as President Biden is sworn in, his administration will immediately put a stop on anything that's in process at the Federal Register, stopping the Trump administration's last regulatory reform or last of its agenda in its tracks. Now, of course, the Trump administration is trying to get as much out the door before then as possible. But as soon as Biden is sworn into office, his administration will put a stop, probably with a memo from the White House Chief of Staff or somebody, to the Federal Register and to the agencies. What's going to follow over the next hours, days, weeks is going to be a series of executive orders from President Biden. Some will just summarily repeal old executive orders that President Trump put into place. Others are going to reform or replace executive orders that Trump took down himself. President Trump used a mix of procedural executive orders and substantive ones. Process on how rules are going to flow through his administration, beginning with his order on regulatory budgeting and the 2-for-1 policy. But even in recent months and years, there's been a lot of sort of organizational executive orders on how the Trump administration wants its agencies to operate. The Biden administration will come in very quickly in many cases and reform or repeal those. It also will replace a number of substantive orders that President Trump issued on issues like financial regulation, energy and the environment, labor policy. On a number of issues, President Trump told his agencies, I want you to pursue these particular policies or principles to the maximum extent possible under law. That was a bit of an innovation or an amplification of an old tool that President Trump really made the most of. I expect the Biden administration to really double down on that. So we'll see executive orders stating President Biden's policies on sort of key issues and telling his agencies to move forward as fast as possible. At the agencies, they'll be delayed a little bit by the lack of Senate-confirmed leadership. The Senate has not been moving forward on any of Biden's upcoming nominations. So the Senate, after Biden is inaugurated, will have to move pretty quickly to get people confirmed. And there'll be a little bit of a delay in things moving forward in the agencies, but not much. Quite frankly, the people who do land at the agencies early will get things going. The agencies will try to do a couple of things. They will stop litigation over Trump rules, try to freeze that litigation while they go back and reform the rules that are at issue. They'll try to stop enforcement of Trump policies as much as they can. The Trump administration was very aggressive in its own right in doing this at the beginning of its administration. It got a lot of pushback from the courts. And my guess is the Biden administration will, as far as not enforcing Trump rules goes, the Biden administration will do less in terms of sweeping categorical renunciations of old rules. And they'll try to do more under the radar, calling it case-by-case enforcement discretion, even though it'll be pretty clearly a policy judgment. And they'll try to just freeze enforcement as much as they can. We're trying to minimize the risk of litigation over that non-enforcement. But most importantly, the Biden administration will start its own new rulemakings. That's a multi-year process, at least 1 year, sometimes 2, to undo old regulations and redo new ones. But one thing to look for is the use of what's called interim final rules. Normally, regulations go through this notice and comment process. The agency announces a proposal, takes in a bunch of comments, mostly ignores the comments, although they say they're listening to them, and then finalizes the rule. But in a case a lot of us were tracking for other reasons recently, the Little Sisters of the Poor case involving a challenge to President Trump's non-enforcement of the Obamacare contraceptive mandate against the Little Sisters of the Poor. Buried in that opinion was a pretty important procedural point where Justice Thomas and the majority said that the agency can move pretty quickly through notice and comment by just pre-announcing a final rule, saying that this is temporary until we really finalize our rule. And my guess is the Biden administration is going to be very aggressive with that and push the boundaries of that new decision as far as they can. It'll be interesting to see how the court reacts to that. So that's basically how the process is going to play out. Let me just put a handful of substantive issues on your radars. This is what I'm thinking about these days in terms of sort of big picture themes of regulation in the Biden administration. One is what I call regulation by expectation or regulation by credible threat. From any administration to the next, there's so much back and forth on regulation, so much uncertainty from one administration to the next. Regulated entities, businesses and others, they have to make long-term plans. They have to look over the horizon of just a year or two or even one administration. What we saw during the Trump years was pretty credible threats by effectively the Biden administration in waiting that policy was going to change very quick, was going to snap back to the sort of Obama administration's policy trajectory, and really urging companies to get on board with that early. We saw that mostly with climate change, but we'll see it in other places as well. My guess is the Biden administration will do as much as possible in the early weeks and months through speeches and policy statements and other things to try to force the regulated entities in the direction of compliance long before the rules are ever actually finalized as a formal legal matter. The second theme I'm watching is regulation versus legislation. Senate Democrats, House Democrats will unveil big legislative reform proposals, and they're going to say they're focusing on legislation. The Biden administration will say it wants legislation. But from the very opening moments of his administration, President Biden will be pursuing a regulatory agenda through his agencies. Those they'll say are operating on parallel tracks, they're really not. The fact that the Biden administration, under existing administrative law and under these broad delegations of power from Congress, the fact that his agencies will be able to do more or less whatever they want to do, or much of what they want to do, is going to undermine the legislative process the way it always does. The fact that Biden will be able to start these programs on climate and on other issues, financial regulation, means that there's going to be much less hydraulic pressure on Congress to actually come together on legislation. So my guess is that the legislative process will fall apart. Biden will say something like, because Congress won't act, I will, even though it's actually just as much the opposite. Because Biden will act, Congress won't. So that's the second theme. The third theme I'm keeping my eye on, there's 5 of them, so I'm halfway through, is OIRA, the White House Regulatory Oversight Office, and social justice and equity. On the one hand, there's been a lot of criticism of President Trump from the center left that his administration didn't do enough on cost-benefit analysis, that they didn't do it right. I actually just moderated a panel yesterday with 3 really smart scholars from the center left on regulatory reform. And time again, they said the Biden administration needs to improve cost-benefit analysis. At the same time, they're going to say, I think the Biden administration will say, the cost-benefit analysis isn't the end-all be-all, and that OIRA and the White House need to make much more space for value judgments with respect to distributive effects, social justice and equity, and so on. And it'll be very interesting to see how they try to balance that, whether they try to do it within OIRA with a new executive order or in the policy apparatus that surrounds OIRA and the agencies. Number 4 is transparency. I joked about that before we got on the air, or when we already were on the air. I just didn't realize it. One of the Trump administration's major priorities through executive orders and at the agency level, especially the EPA, was on transparency, making the agency's work more transparent, more open to public inspection, more records online about guidance documents and everything, transparency on law, on fact, on policy. Those are kind of tricky politically to undo. And I'm really going to be interesting to see how much of that the Biden administration undoes. They'll definitely try to undo the EPA transparency rule. That's been hugely controversial, even though I don't think it should be. But it'll be interesting to see what out of the White House's executive orders on transparency gets changed. Because my theory has always been transparency promoting initiatives are stickier and that there's more of a political cost in undoing. And I guess now we'll find out. And then finally, the last theme, and maybe the biggest, is what I call financial regulators as everything regulators. Financial regulators have immense power and usually a little bit more independence than other agencies, and I think for reasonable reasons. In this administration, we're already seeing calls for the Treasury Department, the SEC, the CFTC, the Fed to take a much stronger role in not just financial regulation, but everything from climate to tech policy to economic inequality to social justice. And so we're going to see those agencies pushing, I think, more and more to become, if not the primary regulators of those subjects, which they really will never be, to strong secondary regulators. I think that's a big mistake. I think it's going to undermine the political institutional capital that those agencies enjoy. I think it's going to be really counterproductive. But we've seen from the very beginning of the Biden transition's first website, right up to the election onward, more and more calls from within the transition and the Senate, the House, and outside groups calling for the financial regulators, like I said, become kind of everything regulators. Now, I plowed through a ton there and probably spoke longer than anybody intended me to, but I hope, I've offered some food for thought, and I'm happy to answer any questions. Although, of course, everything I just discussed is going to get tied up in the courts. So the person I'd rather hear from is Carrie.
I think that's a wonderful frame, Adam. And before even I start us off with some questions, Carrie, did you have any reactions to some of that or elaborations on what Adam put down there?
Yeah, and I think as we were discussing as we prepped for this, Adam and I have been working together for our entire professional careers. We started out clerking, sharing an office as DC Circuit clerks. So we happen to be on the same page on this as in many things. Although I have to say he's certainly much more the expert on the regulatory process than I am on this. But I agree that all of these things, it's going to be interesting to watch the courts, which are look a little different than they did when at the beginning of Trump's administration, but they're going to be in some cases dealing with some of the same questions in terms of what the executive can do through the regulatory process, and how is that going to look different just because it's Trump or Biden, and the nature of that. I think there's a decent argument that there's some judges who appear to take Trump-led cases differently than and not apply the same rules they had to other circumstances. But I think it's also going to be, it's a different set of judges that we'll be looking at because so many of these judges were Trump appointees.
Great. I do want to make sure that we tie a lot of the themes that Adam brought up to specific areas. And one of them may very well be what was the most discussed issue, I think, on the campaign, in the difference between regulatory approaches, which is COVID, how the Trump administration used those levers that were at their disposal, and how the Biden team, and in particular, how Biden himself viewed the executive in being able to deploy federal resources. The Trump administration's COVID agenda has largely been deferential to the states in their classic role as first movers on health, safety, welfare. Adam, but Carrie, if you'd like to also jump in. I mean, what will, but realistically, can a Biden administration do differently on COVID?
You know, they're going to say about how they would have done everything in the past differently, and maybe they would have, I don't know. But I think from here, it's going to be, there won't be a whole lot of difference because so much of what's at stake now really is in the states. Had the vaccines not already been coming online, I would have wondered how aggressively the Biden administration would have pushed the bureaucracy to move forward on those. But now that those are sort of behind us, I think they'll just ask for more funding and try to support the distribution. The real challenge here is going to be on, I think, the collision of state and local COVID restrictions and religious liberty and other fundamental rights. And we saw that bubble up a lot over the summer and in the fall, with some really fascinating and stirring opinions by Justice Alito and Gorsuch and others. And we'll be interested to see if the Biden administration puts its Justice Department on the side of the local regulators and against liberty. I mean, that would be interesting. At the same time, they'll probably come down in favor of abortion rights against local regulation. We just saw, I think, in the last couple of days, Carrie, maybe a new little set of opinions out of the court on abortion and COVID restrictions, maybe just last night or something, I can't remember. But it'll be interesting to see the Biden administration, through its Justice Department, try to push the law in one way or another on that, pushing back against religious liberty, pushing in favor of abortion rights, and really trying to have it both ways on the authority of local and state governments.
Hmm.
Yeah, I think that's definitely right. And it's interesting because we've seen the influence of Trump's appointees on the Supreme Court already on that issue, where the court for a while, and we've seen this trend where Chief Justice Roberts seems to be getting more and more the swing vote of the court. And that was one area that a lot of people were frustrated with early on in the COVID pandemic, was seeing that he didn't seem to be placing very much emphasis on religious freedom and that balance of how do you manage protecting constitutional rights while acknowledging the government's need to address a serious crisis like this. That seems to have shifted now with Amy Coney Barrett's presence in the court. And I think it also, it reflects also a little bit the time frame of the pandemic, because you can say, okay, at the beginning, maybe when there's less of an understanding how to deal with the pandemic, or when you're just at a more critical period, maybe there's a little more leeway that the government can do things without having the full extent of the reasoning maybe fleshed out, because they simply can't in the heat of the moment, in the fog of war. We're now almost a year into this pandemic. And so I think it's also independent of the personnel in the courts. It's understandable that you might see a shift saying, okay, this is not an emergency, split second decision. Now you have had time to analyze these things. We do know how to balance different constitutional interests with the protection of public safety. So that's a little bit of a natural shift, but I think we saw a big change. The decision that came down in the eve of Thanksgiving, for example, challenging Governor Cuomo's regulations. So that I think was a big shift. The New York case that came down from the Supreme Court, which appears to have changed the direction the Supreme Court is going. And now we've also seen a lot of lower courts following suit. I'll point out that that decision is citing also another Trump appointee, on the Second Circuit, Judge Park. And then there's a lot of decisions in this area, Judge Duncan, Judge Ho, Judge Thapar. There's a whole lot of great Judge Walker. It was decision in this area. that shows that there's judges who really feel like we want to give the state the ability to regulate, but you also have to then say religious institutions have to at least be on par with other institutions that don't have the First Amendment behind them.
Great. In addition to COVID, there was on the campaign trail, at least, you had stark division on immigration and DACA in particular. And the court back in June came down with what was a ruling that really seemed idiosyncratic in terms of how they treated administrative edicts from previous administrations, but now introduced a new standard of sort of how an administrative edict came about, being a factor in whether or not you can eliminate an existing program, DACA. So are we going to see on immigration just a retread of the second Obama term on DACA, or are we going to see perhaps a Biden administration now given a DACA that is not eliminated, but rather one that can be resuscitated at the starting point rather than to be viewed any other way? Adam.
This might be a place where legislative reform has more of a chance, precisely because the unilateral administrative stuff is so up in the air. But I mean, I guess I'll believe it when I see it. Anytime you talk about legislation, the Biden administration, obviously, they'll try to move forward with what remains of DACA. And again, this is what I was alluding to earlier. There's a lot that they could probably just do on claiming case-by-case enforcement a little bit more subtly than the Obama administration did. That said, I'll say that on the DACA decision that the Supreme Court issued in the Board of Regents case, I'll be quite frank, I liked that opinion more than a lot of my friends did, because I read it as going beyond just the DACA repeal and being a statement about the future of this kind of policy shift in general. I mean, it's true DACA itself wasn't subjected to that kind of judicial review because the election in 2016 short-circuited that litigation. And my theory has been that if the original DACA case had actually gone to the Supreme Court and gotten a full decision on the merits, that it would have looked a lot like Roberts' opinion would have looked a lot like his opinion in the next DACA case, the one that we had last year. And that's one of those cases, those doctrines that I think could be really important in the Biden years on DACA, but also more broadly. The Roberts Court, generally with progressive justices, has told the Trump administration on census and on DACA repeal, you need to be more forthright and more thorough in your analyses. And we're going to push back when we don't believe that you're actually telling the truth or giving a thorough enough justification for your answers. Progressives love that for the last 4 years. If Roberts sticks to his guns, which he may or may not, I hope he does, and I think he does. I think he will. Then we could see a lot of pushback in the same way, both on DACA and on other agency flip-flops. And so that's another thing that I'm looking for.
Mm-hmm. But Carrie, with now Justice Barrett on the court, is there a change, you think, in how any kind of challenges to DACA that may arise, from the states or elsewhere, how that might get decided?
Yeah, I think that is actually one challenge with. I generally am in favor of having a sauce for the goose, sauce for the gander approach here, and that's one of the things that was frustrating about that DACA decision. Is a lot of people said, "Hey, wait a minute, how come if Obama's not being held to put in place a regulation or a refusal to prosecute a decision, if he's not being held to these procedural standards, how on earth can you hold Trump to those procedural standards to remove that illegally constituted thing?" Of course, Chief Justice Roberts was the swing vote in that case. And I suspect if you had today's composition of the court last term, he would not have been the swing vote. I suspect you would have seen, we don't really know the answer to that yet because we haven't seen, Justice Barrett in that context. But so you could have the situation where maybe Chief Justice Roberts does stick to his guns, but you could still see a flip in the outcome. And that would obviously be frustrating because then you get the same problem where the Obama and now the Biden administration get a, complete green light to effectively legislate by pen and phone in certain cases, and the Trump administration doesn't. Now, that said, I do think it's going to look different if he's trying to actually do rather than undo things. So I think with the current constitution of the court, you're going to see a very strong defense, both at the Supreme Court and at the appellate courts, because you've seen there's some very strong decisions I've already seen talking about the structural limits on government, and making sure that those are obeyed. So if you have a pen and phone approach from this administration, I think that's going to be quickly addressed by the courts. It's the repealing. It's going to be interesting to see if that goes along the same lines as last June's case did.
Great. Adam, you, I think, gave us some really great starting points for what might be some of the substantive priorities for the Biden administration on environment, but maybe even also housing reform, and then labor, in particular, because those three agencies were granted wide discretion under the Trump administration to reverse the second Obama term's regulations. What can be done via regulation to meet the goals of, for example, the Green New Deal, with a Biden administration filled with regulators that are really seeking to push the envelope? As you said, what realistically can you do using financial regulation to achieve the substantive ends of the Green New Deal?
So, well, I'll start with that last point first, and circle back to the big picture. I mean, on financial, I don't want to overstate it, but like I said, they're not going to be Treasury, or the SEC is never going to be a primary climate regulator. But what they're going to try to do is impose a lot of disclosure and market-centric regulations that are going to, I think, reinforce their main climate programs. What they want to do in general, and the Green New Deal means a lot of different things to a lot of different people. A lot of it is just spending, and they're going to do that. There'll be a lot of spending. They'll talk about green infrastructure, but to the extent that they don't reform permitting laws and the National Environmental Policy Act, which is the statute that governs all the environmental reviews, to the extent they don't reform that, they're going to be stopped dead in their tracks, just like they were during the Obama years. The core of it, in terms of regulating automobiles, they have a lot of leeway now under the Clean Air Act and the CAFE standards that the Department of Transportation, the corporate annual fuel, or corporate average fuel economy, CAFE standards that the Transportation Department administers. They'll be able to do that. The big question is, how much can they do through regulation on, say, cap and trade or things like that? The Obama administration obviously tried a lot with what they call the Clean Power Plan. Like DACA, that was another big program that was teed up for Supreme Court review. In fact, the Supreme Court had put a temporary stay on it before it could reach the court even. And then the 2016 election mooted the entire dispute. Mm-hmm. And so that's a really open-ended question that the last the Obama administration and the Supreme Court at the time left open. How much can they do under the Clean Air Act in terms of cap and trade and those things? They can't impose a carbon tax or anything like that without legislation. But the regulatory power is a little, bad pun, but a little up in the air right now. And my guess is that they're just going to pick up where they left off with the Clean Power Plan, knowing that they probably have some headwinds from the courts on issues of deference and so on that maybe we'll get to later. But they're just going to pick up where they left off and see how far they can get with it.
Mm-hmm. You know, Carrie, the old saying, personnel is policy, I think is going to drive a lot of discussions about the Biden regulatory agenda, what with expected nominees such as Javier Becerra for HHS, Vandana Gupta at Justice, Jennifer Granholm at Energy. These are real culture warriors of the left. Are we going to see any moderation in issuing these kinds of regulations now that there's a Democrat Senate?
Yeah, what we've seen is, with some exceptions, I do think, Merrick Garland as AG is actually one of the more reasonable than most things I was expecting to see out of a Biden administration. I think what we're seeing is an embrace of some of the loudest voices on the left. And one of the things that's kind of chilling for me is I remember last year during the Democratic primary, I'm always someone who is advocating for Supreme Court lists to be disclosed to the public. Go back to the transparency point that Adam said, but it's something that none of the Democratic hopefuls wanted to do, but Demand Justice, a very far left group who is kind of on the opposite end of the spectrum from what I would advocate in judicial nominees, put out a list, and it was 32 basically activists. I think 8 of the 32 were even judges. So these are the people they're talking about for judicial positions. But what we've seen is already several of those people, like the Becerras and the Guptas of the world, they're on that extremist list, and now they're in the cabinet. And I don't doubt that many of the people on those extremist lists are going to be soon on the bench as well. So what you're seeing is him reaching to some very bold choices, and it's people who have a very are happy to move forward at full steam, and in some cases really troubling positions. I was just looking at information on Kirsten Clark, who's the new head of the Civil Rights Division at DOJ, or will be, and some of her statements basically amount to outright racism and Black supremacy. I don't think we need to be in favor of Black supremacy, white supremacy, anyone's supremacy. Let's have someone who's especially involved in civil rights should be looking at a more balanced approach to it. And I think Becerra, again, his single claim to fame in the Department of Health Policy seems to be in attacking conscience rights, attacking people like David DeLayden for uncovering what was going on with Planned Parenthood's sale of aborted fetal tissue. It's worrisome because I think these are bold, progressive choices by Biden in all these areas.
So if we could shift now to kind of how the Biden regulatory agenda is going to be met in the lower courts and at the Supreme Court. 54 new appellate jurists in the last 4 years, largely jurists that were chosen for their originalist bona fides, not all of them, of course. 3 Supreme Court justices that were put through the gauntlet as well. Even if we, I think, the James Wilson Institute wish they were a little more embracing of natural law, definitely steps in the right direction. Carrie, what kind of, for lack of a better term, resistance will these opinions from new jurists offer? Are we going to get the kind of opinions that can teach a new class of, I think, conservatives who care about the Constitution, who care about first principles, or are we going to get kind of whatever you want to call, whatever you want to say about Mark Tushnet? Are we going to get defensive crouch conservatism from these jurists? It might be that these jurists fill a void while the Republican political class looks for answers. These jurists offer some of the most luminous examples of how to be statesmen. Maybe I'm expecting too much of them, though. What do you think?
Well, I have to say this group of judges, in particular the appellate nominees, are anything but defensive crouch. This is the real gold standard, I think, for nominating men and women who have spent their careers not just thinking about originalism and textualism, but applying it. And I think one of the key features you saw that characterized a Trump nominee is people who stood up when they knew they were going to get pushback on all of these issues. People who took these bold stances at a time, under the Bush administration, for example, taking stances on these issues was a classic way to get off of a short list for any judicial seat. And but those people took the positions they did because they knew they were right. And it turns out in the Trump administration, that was actually an endorsement, realizing that this was someone who was willing to stand up for their constitutional position and not simply try to duck and cover, not try to keep their powder dry in hopes of cultivating a good-looking, a very neutral-looking resume. So what we have here are judges who display a kind of courage that we have not seen from Republican political appointees in my lifetime, at least in terms of the broad sense. Obviously, there are individuals who stand out for that, going back decades and generations. But as a group, they are very unique, I think, in that way. And on one side, does that mean we're going to get conservative results from these judges? I think not necessarily, if by what you mean these conservative policy results. So if, and I think it's a pretty big if they were actually able to achieve legislative goals, now having both houses of Congress and the White House, I suspect, first of all, that those wouldn't be goals that many of these Trump judges might agree with on a policy level. But I think you would see them applying them because they are to a man and to a woman. The textualist instinct is very strong, and that is their approach to the law. And you have some great decisions already coming out of these judges talking about we have to simply apply what the text is. I've spoken to judges who said this is the hardest part of the job because sometimes the law is just really bad policy. It's wrong-headed. It's sloppily put together. It's out of date. We all know this is true. It's all sausage, but they have to actually apply it, even when it's not their personal taste of sausage, right? Maybe the good news, I guess, if you're hoping to get conservative results out of these judges, is that it's probably unlikely that you're actually going to get any real legislation, major legislation through this Congress, unless they go whole hog and get rid of the filibuster, which, God forbid. I think that would be really damaging to the institution. And I'm hopeful that will not go that far. But in the case where they're simply, again, limited to pen and phone, as Adam was outlining earlier, and that Obama style governing, I think you're going to see courts, and we already have seen courts that are particularly protective of the constitutional limits on executive power. And I think it's also significant that we are at a high watermark for concerns on the federal bench and all the way up to the Supreme Court about the deference to administrative agencies that we have seen, that Scalia helped usher in, actually, but then I think later in his career realized was actually wrongheaded, both in a practical level and really in a constitutional level. And so we are now at a point where we may see have teed up for real action, even from the Supreme Court itself, a pushback on that deference, the Chevron, the Auer, Seminole Rock type deference to agencies. And if that pushback happens, that's going to ultimately limit what the Biden administration can achieve through these regulatory agencies. And obviously all future administrations as well, which in my mind is a very good thing, because we need courts to be doing the job of interpreting statutes and not simply effectively delegating their responsibility to a government bureaucrat somewhere.
Great. Thanks, Carrie. I did want to invite Adam to pick up on one of the themes you just brought up. We often hear about how the court will engage in a years-long process of chipping away at certain precedents. Is it likely, or is it realistic to think that on the legal edifice supporting the administrative state, precedents such as Auer and Chevron are at such great threat to be significantly chipped away in a 4-year Biden administration? Maybe you would think Auer could be, Chevron wouldn't be. Just your thoughts on where we're likely to go, especially after decisions in the Trump years, such as Kaiser versus Wilkie.
On this point, there's a way that Carrie put the point just a moment ago that I thought was perfect. She said, judges have concerns. I think that's right. There's a lot of judges out there on the Supreme Court and on the lower courts who are uneasy with the current state of affairs. As Carrie said, a lot of these doctrines, the light touch on deference, the light touch on non-delegation, those were brought about in the early Reagan administration into the 1990s, I think for justifiable reasons. But the pendulum swung too far in the other direction. And now we're in this course correction. So I don't expect to see anytime soon massive overhauls, a renunciation of Chevron deference and just, complete de novo review of every statutory interpretation, an aggressive non-delegation doctrine. Those are really hard doctrines to work out. It's really hard to draw lines for those things. And so what I think we're going to see is the court both reconsidering precedents, recalibrating them, and just trying to, in some ways, seeing the energy from some of these doctrines just work its way into other places. What I mean by that is, obviously, we now have 5 justices who are worried about overbroad delegations of power from Congress to agencies, thinking that might violate the vesting of the legislative power in Congress. Are we going to see a new and sort of strong non-delegation doctrine? Maybe, but probably not anytime soon. You will see those concerns inform the judge's judicial interpretations of statutes, right? Saying we need to construe such and such statute narrowly to avoid these non-delegation doctrines. We saw, again, a little bit of that coming up from lower court judges at the end of the Obama administration. And I think we're going to see that discussion resume. Chevron, I think, will be recalibrated in some ways. It never really had a thorough theoretical justification. It was sort of a bundle of justifications, and we've seen the tensions between those justifications, between democratic accountability and technical expertise and the duty of the judge to say what the law is. We've seen those tensions play out now over 35 years, and the courts are going to come to grips with that. So I'd say look for an ongoing sort of deliberation, discussion among judges and scholars in the years to come over non-delegation, over deference. You mentioned the Kaiser versus Wilkie case, which is a good example of this. The court didn't throw out the old version of deference. We called it Seminole Rock deference. But they said, we're going to recalibrate it to prioritize steadiness and accountability and so on. So that was deference. We're going to see questions about process. Like I said, there was some of that during the Trump years and the DACA and census cases. We'll see more. And by the way, I see Justice Kavanaugh looking over Carrie's shoulder. He's very worried about the courts layering on too much process in the name of the Administrative Procedure Act. He said that 15 years ago in a case involving the FCC, and it'll be interesting to see where he goes. And then finally, we're seeing the courts start to grapple with just remedies, right? Nationwide injunctions and so on. Justice Thomas has raised concerns about those, others have too. And so I think the next 4 years, we're going to see a lot of deliberation and debate. I don't think we'll see any answers anytime soon, but I think these things will move in important and good directions.
Mm-hmm. Yeah, I think that's probably right, Adam. Carrie, I think I'd be derelict in my duty if I didn't bring up the clash that we're likely to see a retread of since the 2016 election foreclosed the litigation over the GG case, even though certainly after Bostock, there's likely to be a renewed interest in it. But how are we going to see these lower courts grapple with that decision, grapple with Bostock and the transgender challenge? It seems like we're in a position where we're just not quite sure how Gorsuch's decision in Bostock will be distilled. But the key difference is now we'll have an administration pushing Bostock instead of reluctantly accepting it.
Yeah, well, the good news here is that I think the bad news, as you laid out, is I think you're going to see these clashes continuing and increasing. The good news is I think we have courts that are right now very strongly protective of religious freedom. And frankly, even Justice Gorsuch himself, who obviously wrote the Bostock decision, and maybe even his predecessor or his former colleague and Kavanaugh's predecessor, technically, as Justice Kennedy, I think, though he was a major figure in moving the law in the direction where the Obergefell case talked about religious freedom trying to be able to coexist with some of these rights that he helped advance. He was supportive in the Master Keys Cake Shop case of those rights when the conflict occurred, and I think Gorsuch shows every sign of being potentially even more so. When you look at some of the religious freedom cases that came out of last term's cases, that was one area that, while it was a disappointing term on many other aspects for conservatives at the court, the Espinoza case having to do with the Blaine amendments, the Guadalupe case and the ministerial exception, the Little Sisters of the Poor case, the court was kind of firing on all cylinders when it came to religious freedom. And I think they're recognizing that, okay, if we are increasing the amount of weight over here on one set of rights and interests, there does have to be a counterbalance, or you're going to end up with a constitutional, the very first right protected in the Bill of Rights that's going to be threatened. So we've seen that at the Supreme Court, and then we've seen a number of cases at the lower courts recently that, again, we mentioned the COVID cases, but there also have been recent decisions involving everything from legislative prayer to ministerial rights in the church's right to not to be free of lawsuit by its own ministers. You've got cases having to do with public displays and the establishment clause kind of line of cases. So it's been there have been a lot of really strong showings by the appellate courts as well. So I think that's a good sign, because at the end of the day, I don't think it has to be an either or on these cases. We have long been a country that has had a live and let live approach, particularly when you come to issues of religious freedom. That's how we've been able to survive as a religiously diverse country this far. And so I think the courts are going to play an important role in making sure that that still is a possibility.
Well, live and let live is probably best expressed in our Constitution by federalism, right? And that's probably going to be the avenue by which a lot of these one-size-fits-all national policies are challenged. And while the setting for a lot of the challenges in the Trump years was California, Washington, Hawaii, the Ninth Circuit, are we going to get a retread of that in the Biden administration, but instead in Texas, Louisiana, Fifth Circuit, Ohio, in Kentucky in the Sixth Circuit? What are your thoughts, Carrie and Adam, and just kind of how federalism will bring these questions to the fore and maybe be a way to resolve some of them?
Yeah, I think you're right. Although the Ninth Circuit is a different Ninth Circuit today than it was 4 years ago, which is a really good thing. We've even had some important wins in that case. But certainly, if you're a Republican Attorney General bringing a lawsuit in this era, the Fifth Circuit is great. The 11th Circuit is really strong now, and that's one of the ones that Trump has had a major impact on. The Sixth Circuit has some really outstanding judges. So there's a lot of places we're going to see these cases being brought that have renewed strength and really analytical weight too, because that's what's the most, I think, significant impact of having good appellate judges. You want to have judges that are not just going to say, okay, we're ruling the right direction, but someone who is sophisticated and smart and can provide that kind of argument that the Supreme Court is going to look at and say, actually, yeah, that's a really great way to analyze it. So you're going to see those bubbling up probably in more than one circuit in some of the major issues. And that helps really provide a good framework that the Supreme Court then can use in its own analysis in many cases.
Mm-hmm. Adam, do you agree?
Yeah, I agree. I think we'll see the usual pattern of litigation, right? You'll see a lot of red state attorneys general line up to challenge particular regulatory initiatives, and we'll see the blue state attorneys general line up to defend the administration. It was reversed during the Trump years. It was reversed before that in the Obama years, and so on. I was going to say one thing about this. Oh, one thing I am worried about this is I think that to the extent that red state AGs do what the blue state AGs did in the last 4 years, you're going to have now with the Senate in Democratic hands, you're going to see Sheldon Whitehouse and others pitching a bunch of conspiracy theories about this and trying to investigate the litigation against the Biden administration. I think you'll see that really the Senate, a couple of Senate committees really running cover for, or what do you want to putting air cover out for the Biden administration by trying to deter litigation, just run-of-the-mill regulatory litigation against the Biden administration by conjuring up conspiracy theories and allegations and so on. I am very worried about that. It's going to be, I think some of those committees will be doing more oversight of Republican AGs than they will oversight of the Biden administration.
Yeah.
That's too bad. As promised, we do have ample time for questions, and we do want to turn over to some of the questions that have been posed in the Q&A function for all of our attendees, though, who have a question perhaps at the forefront of their mind, but they haven't put it down yet. We invite you to use the Q&A function to please submit a question. Either you may submit your question anonymously, and I'm happy to read it, or you may submit your question and either I can read it on your behalf or we can give you the microphone and you can ask it. Our first question is an anonymous one, and I think it's for either Adam or Carrie. What happens when a Trump rule is challenged in court? Can the Biden administration simply stand down or agree to a settlement of some kind?
Maybe I'll take that. the Biden administration, the Justice Department, the agencies will ask the court to hold the case in abeyance because they'll say this rule is going to be reconsidered, examined, and possibly repealed. I mean, surely repealed, but they'll say we're considering this now. And so please put the case on hold. The court will put it on hold and things will kind of freeze in place. Eventually the agency will start doing its own thing. Settlement is a possibility. We saw a lot of that in the Obama years of sort of phony litigation, right? It would be an agency would get sued by a public interest group, and the agency would say, oh boy, they got us. So we were totally illegal here and we need to settle in order to, that was my handcuff hands, by the way. We need to settle and commit. We need a court order that will all, a consent decree, we will all sign saying the agency is really bound by law to do this. That was really, a subtle and effective tool of theirs to lock in an agency, both in its immediate years and then in the years ahead with some consent decree where the agency and the outside group committed agency resources for the long term for a particular regulatory or policy initiative. So I think we'll see a lot of that. But at first, it's really the first step is going to be the agency saying to the courts, can we please just put this litigation on hold? And I don't think there's anything wrong with that, by the way. I think that's just a fact of changing administrations. It's what happens after that that both the judges and outside groups need to keep an eye on.
Excellent, excellent. Carrie, anything to add?
No, you were just putting me to mind of some of the other interesting, I guess, not regulation, but or law making by settlement techniques that I've seen that we saw during the Obama era that we need to keep an eye out for now. One of which is another kind of collusive settlement type thing where you saw cases being brought. Then this would be sort of an enforcement case being brought by the administration, and then getting some kind of a consent decree or settlement, but that would involve monetary payments, often to a third party that could be like an Acorn type. Now, obviously, Acorn doesn't exist anymore, but a liberal special interest group that the government would say, well, here, your penalty is this amount of money. And then they would effectively just be doing a monetary transfer to a liberal special interest organization. It's something that the Senate has looked into a little bit at the beginning of the Trump administration, and I would hope that's not something that's revived because it's a real serious problem in my mind. Another kind of settlement strategy technique that we saw used during the Obama administration that you could see revived is, especially in the face of courts that are going to be defensive of constitutional rights in certain cases, is the strategic settlement of cases that you think aren't going to go your way. And this happened in a series of disparate impact cases where there was a question as to whether disparate impact was allowed under the Civil Rights Act, and it turns out in the end, Justice Kennedy voted that it was. So maybe all this was for naught, but for a while, everyone thought the Supreme Court's going to say it's not in there. And so every time a case started getting close to being taken by the Supreme Court, or after it had been taken by the Supreme Court, suddenly it would get settled, and and then they wouldn't be able to quite get to the place where they would have firm, settled precedent saying that it wasn't there. So that you may start to see this again where, okay, the Biden administration is going, and it looks like they're going to lose, and maybe lose big on an important point that they don't want to have written in Supreme Court black letter law. And so then you just settle the case and try again later and hope that in the meantime you can change some of the judges or get a better set of facts or one thing or another. So there is a lot of room for interesting strategy on those fronts.
Great. Our next question comes from one of our 2020 James Wilson Fellows, Daniel Vitaliano. Daniel asks, are there particular public interest groups, law firms, or states that you expect to spearhead legal challenges to the Biden administration's regulatory agenda? Where do both of you recommend that young lawyers look for opportunities to get involved in legal challenges?
Well, I know there's we were talking about religious freedom issues, and certainly groups like Alliance Defending Freedom and Beckett Fund. I realized I've been drinking out of my Beckett Fund cup I used to work there. My husband used to work there, so big fans. But groups like that are going to be certainly working on the religious freedom front. But I think you're going to see a lot of places expanding into, making sure, watchdog effectively type litigation in other areas as well. Maybe Adam, you have some other ideas of other groups to look into, but.
Yeah, I mean, I'm a big fan of Beck as well. I saw your mug earlier and I was jealous actually. I'd say in sort of my little world, the administrative state, there's some really great groups. There's Philip Hamburger's organization, the New Civil Liberties Alliance. There's the Pacific Legal Foundation. There's Institute for Justice. The Cato Institute files great briefs too. I mean, I'm leaving out ones. There's the law firms that have taken the lead on some of these things like Cooper and Kirk, Consovoy and McCarthy and others. And in the big sort of regulatory cases where industry has a lot at stake, you see firms like Sidley and Kirkland and Ellis, taking the lead. A couple of groups, I'm kind of interested to see how some of the organizations that used to take the lead in litigation like this will be. The Chamber of Commerce, the Business Roundtable, and others. Especially the Chamber of Commerce's litigation center was a core participant in these sorts of disputes in the 90s and 2000s. In the last few years, there's been this move towards, what's called ESG, environmental, social, and governance policies. Big corporations becoming more partners with government, less adversaries. This reminds me a lot of what Louis Brandeis wrote about in Other People's Money a century ago, but it's where we are now in a progressive direction. And so I'll be curious to see how much the Chamber of Commerce and the Business Roundtable gets involved. But even if they don't get involved, the firm I left out, of course, my old firm, when I practiced with Boyd and Gray and Associates, they'll be front and center on a lot of this litigation as well. And I think there's going to be a powerhouse of legal talent in both the private sector and the public interest sector that's going to make for interesting litigation. And in the states, the states with the most capacity will lead the way, starting with Texas. But the Solicitor General's offices have continued to become more developed, more professionalized, really great. I get to talk with these folks from time to time. And I'm curious to see which states step up more than before, just because they've built up their capacity and their expertise in recent years.
That's a great point. We have a few more questions. I would like to invite our founder director, Hadley Arkus, if you'd like to get in now. Hadley?
Sure. Can I get in?
Yes, you're on.
Oh, not by video. Okay.
I can put you on video.
No, it's okay. It's a line from Tommy Magliazzi. I have a face made for radio. That's okay. But first, I want to say we have not only two, but I think three illuminating presentations today. You're just a model of clarity. It was a pleasure to listen to. I have a question for Adam, but I want to float a theory to carry along the way that my sense is that the appointment of Amy Barrett allows John Roberts to swing to the conservative side again, for the same reason he would swing to the other side with the transgendered case, for the sake of making it 6-3 and firming up the decision and putting it a little more out of reach and out of the prospects of an active engagement in the political arena to overturn it. But at the same time, as we saw with the decision yesterday, he could use his presence on that majority of 6 to shade the opinion his way, to narrow it, or in the case yesterday, to suggest it had nothing to do with abortion at all. But I don't leave Carrie here for the next question, because our friends at HHS brought forth in the Civil Rights Division, and she has friends there. Civil Rights Division has done a terrific job, of course, in taking the lead in protecting religious freedom. They brought forth a final rule a couple of days ago, you might have seen that, to sweep away the directives put in the Biden administration without any statutory ground now, creating rules on discriminations based on same-sex, the refusal to fund in your medical plans same-sex couples, or now the transgendered would be the transgender. We suspect that since Bostock, a Biden administration will have no hesitation about putting under sexual discrimination the discrimination against the transgender. So, do you have any speculation as to how aggressive they're likely to be? You could put so much strain on small Catholic schools, small religious schools, across the board. And not just to say nothing about, there were threats about removing tax exemptions from institutions that don't accept are at odds with federal policy. I tend to be an alarmist here, Adam. What's your own sober sense of how this is likely to go? How much you think they're willing to push it?
Well, let me start with the first point about Chief Justice Roberts, and I'll give Carrie the first shot on the HHS issues. Or maybe she probably has more to say on Roberts as well too. But I'd say this: yesterday's opinion, I looked it up a little bit ago, is a good example of where I think Roberts is headed on this. The case was called FDA versus American College of Obstetrician and Gynecologists. And it had to do with FDA regulations that in the COVID environment, these groups said was too much of a burden on the right to contraception and abortion. And the district court had ruled against the agency. The Supreme Court undid the district court's original injunction. And Roberts, in his separate opinion, said, as I was saying in the New York case and elsewhere, this is a time where we need to be deferential to the judgments of the experts in what is sort of medically necessary and so on. Roberts was saying to the left, you liked what I was saying when the cases involved religion. Well, I'm still saying it now on these other things. And I think that's an example of where he might be headed, again, with an eye to the census and case and the DACA case. Obviously, Roberts isn't the swing justice. He plays less of a role in that respect. And the fact that 5 justice majorities might be in place regardless of his vote might, leave him in a position to try to narrow the majority opinion that he's joining. And I agree completely with that. I continue to think, though, that in many ways, not in every way, but in many ways, the most consequential justice on the court right now is Elena Kagan. She is the first progressive justice who speaks textualist as a first language. And she is in a position to take a lot of these subtle tensions and ambiguities within originalism, handle the sorts of things you've been debating with Scalia and Bork and others for decades now, about the principles underlying originalism. She is able to sort of hone in on some of these questions and amplify them and really force conservative justices to explicitly confront otherwise latent or subtle disagreements amongst themselves. And we saw that the Bostock case more than anything else. And I'll be very interested to see how the relationship between Kagan and Roberts and the various conservatives on the court plays out. And in many ways, I think Roberts is going to be playing sort of a reactive mode, trying to take some of these disagreements among the conservatives and with as well.
To muffle them. But what is your sense about how aggressive the Biden people are likely to be in pressing these rules on anti-discrimination based on sex?
Oh, I mean, extremely aggressive. I mean, I will say one of my biggest worries in the last few years in the court was the eagerness of Justice Ginsburg and Justice Sotomayor to try to rewrite the Religious Freedom Restoration Act to sort of amend onto it this new sort of third-party injury standard that said anytime somebody else's rights were at stake, RFRA just doesn't apply, and that just negates RFRA. And I mean, with the change on the court, that's been derailed a bit. But I think we'll see the Biden administration push as hard as they can. And I think that what conservatives also need to worry about a lot is not the repeal of RFRA, but on substantive legislation, I'd say watch for Congress to sneak in little RFRA exemptions, right? To say that we are saying here that RFRA doesn't apply. And in the Biden administration's own justifications for what it's doing, it's going to have to say over and over again, this interpretation, which runs over the rights of religious communities, is commanded by statutory text. And from the ground up, from the moment they begin undertaking this initiative all the way to the end of judicial review, they're going to have to really emphasize an argument that the statute directs this and overcomes any presumptions to the contrary under the Religious Freedom Restoration Act or other doctrines of deference. And they'll say that there's no way we can tailor this any more narrowly. But Carrie knows this stuff as well as anybody, and so I don't want to hog up all the time on this.
I think that's a great point, Adam, that they're going to try to get that in there, because the great thing about RFRA is it does purport to cover all past and by default all future laws. So there should be a religious freedom element assumed in all laws, unless it's explicitly repudiated. So I think there will be probably efforts to sneak that in. I would hope that our friends in Congress are keeping an eagle eye out for those and not letting them go unchallenged. But I think you only have to look at the way that this recent announcement was spun by the press as if this is somehow taking away a broad scope of protections that are in law, when in fact what it's saying is you cannot, short of the Constitution and actual written federal law, not just regulations passed by a bureaucrat, you can't require religious organizations to recognize a same-sex marriage, for example, because that's a religious freedom right that exists not only in the Constitution, but in the Religious Freedom Restoration Act. So simply by bringing regulatory law in line with the Religious Freedom Restoration Act, it's being presented as if this is somehow rolling back protections, but the protections that were, to the extent that they existed, were illegal because they were in violation of federal law. So are they going to be aggressive in pushing back on that? Absolutely. I think Adam's completely right, and I'm sure you expect exactly the same thing, Adelaide. So it's something that we need to all have on our radar. In terms of Chief Justice Roberts, I think it's going to be very interesting to watch how his role changes now that he is the superfluous conservative vote, not the swing vote. This is really maybe a test of how committed he is to minimalism if he tries to join things just to minimalize them. Although I will say, I'm not sure how effective if he takes that strategy. I'm not sure how effective it will be, given just my kind of read on the personality of the 5 conservative justices. I certainly, Justice Thomas is being the one I know the most. He's unlikely. He's not a justice who's likely to modify his opinion for the 6th vote. He's someone who might allow a footnote. If you need someone's vote to get the 5th vote on your thing, absolutely, let's write the narrower opinion. But I think he strikes me as someone who would, if I've got 5 votes, I'm writing it, and you're free to write a concurrence or a concurrence in the judgment. I think that's going to be clearly true of Thomas. I think it's very likely true of Alito, Gorsuch, Barrett. Kavanaugh might be the one person who he might be able to appeal to a little more. But I think in general, it's going to be up until now, Roberts was the one most often, I think, that you would say, okay, he's the guy who's gonna let them slip that extra footnote in. I think of the Trinity Lutheran case, for example, the footnote 3 that he got Kagan and Breyer to sign on to it, but then this added this footnote that effectively watered down the opinion significantly, or gave a huge loophole in the opinion in terms of how broad its scope was. I don't think you're going to see the current 5 justice conservative group as open to that type of move. I think also, one of the other things that may take some of the pressure off of Roberts, one is he's not the swing vote, so you're going to see less of the political and public and media pressure on him, which is only a good thing. One would hope that wouldn't be effective in any case, but whether it's true or not, the perception certainly is that John Roberts is someone who is susceptible to that, and that's why we've seen it increase in volume in the last few years. It's kind of, as a mother of toddlers, I can assure you that if they get the idea that you're going to give in to tantrum, they will have more tantrums. And I think that's unfortunately maybe the dynamic we have seen. Whether it's true or false that Roberts has been switching his votes in cases because of the media pressure, that is the opinion that the media has, and so it just increases the stridency of their appeals to him. That's not good for the court. So maybe that'll take that down a notch. Yes, go on.
No, I think it's really an apt point. But of course, John, as Chief Justice, can insist on assigning himself the role of writing the decision, and Clarence would be writing. He'd be writing as a concurring opinion.
Right, but if you get enough concurring opinions, you don't have 5 votes for that principle anymore. And I think we saw that. That's frankly what happened in the Trinity Lutheran case too. So you've got a concurrence that says you got enough justices saying actually not footnote 3, and you get essentially a line item veto by concurrence of certain parts of that majority opinion. And so you'll see that happen. I think it also, having Trump out of office may free Chief Justice Roberts up as well, because another
Right.
perception, particularly look at last term's cases, is that some of these cases he's applying this sort of sui generis Trump approach to the case. And, so would he have decided the census case the same, the DAPA case the same, if it were any other president? It's not clear. We don't know. Maybe this is our opportunity to find out.
That's
So,
right.
but now we don't have that confounding factor of President Trump, who from the outside at least, I don't believe the crazy rumors of he's swearing in the Chief Justice's chamber saying we've got to get this guy out of here. I don't that doesn't sound to me like him for a minute. But I do think that my perception, again, completely from the outside, is I don't think there was a lot of love lost between those two, and I think it will be easier to have a different occupant in the White House. I think that'll increase the likelihood that we're getting a steady jurisprudential streak, at least, and not having that confounding the analysis there as well.
Thanks, gang. I've actually learned a lot today. Thanks so much.
We have time for more questions, so I'm just going to dive right back into the queue. There was another question from KW, picking up on the response to the first question about what the Biden administration will do with ongoing challenges to Trump administration actions. What about cases where the Trump DOJ was defending laws, regulations that the left doesn't like, and the status quo is in favor of the law? KW is thinking of particularly the ACOG versus FDA case, where the Supreme Court just issued a stay of enforcement of a lower court injunction against the enforcement of FDA regs rejecting the dispensing of chemical abortion drugs. Can the DOJ just walk away from defending those regs?
Go ahead, Carrie. You're going to say something?
I was just going to say that did happen on some cases 4 years ago. So it wouldn't be the first time, and it's the Department of Justice is under the president, and so his policy goals do change. But I think it's true that's going to have an effect that is beyond just the cases that the administration brings itself, and frankly as amici as well, because they were involved in many cases as amici, and you're going to see the valence of those of the weight of the Department of Justice shift.
Yeah, I agree totally with that. As I alluded to earlier, in many cases, the Justice Department is going to say to the courts, with the new election, there is going to be a reconsideration and possibly a repeal of the rule underlying this. Please give us 90 days to ascertain where this is headed next. And the judges, by and large, are going to grant that. They're, mostly don't want to sort of turn what's the line from Shakespeare's, the story told by an idiot, full of sound and fury, signifying nothing. I mean, they don't want their courtrooms to turn into that, litigating, policies that are going to be mooted by just the change in elections. Sometimes it's tougher. I mean, sometimes if the challenge is a constitutional challenge, right? The Constitution isn't going anywhere. The statute isn't going anywhere. And so the Justice Department's going to have to decide its new position. And there are some norms within the Justice Department about big flip-flops. But what we're really mostly talking about, maybe, and I don't know if any of those cases are out there. I think it's all basically regulatory cases. And the question is just, can the agency have some space to redo things? The Trump administration got a lot of pushback from the courts when it tried to, stop things in their tracks. I think a lot of that was cases filed in courts where the judges were particularly suspicious of President Trump and his administration. I think the judges were often a little heavy-handed on that. I think that in many cases, the new Trump administration got a raw deal from some district court judges. But in general, I think, the courts are going to leave space for the agencies to reconsider their policies. It's funny when you look back at the 2016, you had, again, the Clean Power Plan was getting teed up for Supreme Court review. DACA, I think, didn't it go to the Supreme Court, but then with Justice Scalia's passing, there was a deadlock court, so you didn't have enough to decide it. The Waters of the United States rule, net neutrality, these things were all teed up for Supreme Court or on their way to the Supreme Court. If Hillary Clinton had won the election, you would have had really, I think, significant constitutional and administrative law cases up, and then they all just disappeared because of the election. And that's just how it goes. I mean, it's kind of a whiplash, and Roberts gets frustrated with it. He sometimes teases the lawyers for changing the position just based on elections. But that's what happens when you have an election every 4 years.
Yeah, and related, there's another question. This one's from Anonymous, but I think of the same spirit. Can the Biden administration issue contradictory guidance documents from the ones the Trump administration issued? What's the standard for issuing contradictory guidance across agencies?
That they definitely can, so long as the guidance is interpreting a statute or a regulation that's ambiguous. The new administration can change its mind, and can change its mind just like that, because guidance just interpretations of regulations, they don't usually have to go through notice and comment. And so in this flurry of new executive orders that I alluded to early, you're also going to see a flurry of agency guidance reversals. My guess is that people kind of surrounding the Biden transition have been planning this for years, sort of getting their ducks in a row in case a Democrat would win and the new administration could come in and just, with the snap of a finger, repeal old guidance, repeal old executive orders, and put new ones in. The Trump administration came to office with that plan. I assume the Obama administration did, and I assume the Biden administration will.
Carrie, in recent years, some of the most significant religious liberty advances came from agency actions. How do you think the religious liberty landscape will change from the perspective of administrative actions? In particular, what do you expect will happen to the Center for Faith and Opportunity initiatives that were created in every agency?
Yeah, I mean, this is an area where, again, you're going to lose the weight of the federal government in favor of religious freedom, recognizing conscience rights, et cetera, and to maybe being less likely. I think I would hope that they still recognize that conscience rights are something that affect all of us, on all sides of the political spectrum, from every different religion or no religion at all. You've got a conscience and you have a right to, under our Constitution, to abide by it. But I do think it's something that the left often tends to see as view as a threat and as an excuse to violate other civil rights or things like that. And so I think that's something that we need to hope there is some maintenance of, or at least that we hope that it doesn't become a full-fledged about face and attacking those conscience rights. At least it may be a lower level of enforcement of them. But I would certainly say, as Americans, we all still have those rights. So to the even not believing that they're necessarily going to be enforced as vigorously, I would say it's still worth sending in complaints to the agencies if one believes they are being violated, because I think that makes it more challenging for them to say, well, this isn't really an issue. This is really just a cover for some political agenda. If there are, any examples that there are, I think need to be brought up and made clear so that the agencies are forced to address and acknowledge the fact that there are real religious freedom rights that are at risk today.
Yeah, Garrett, can I just jump in with a quick word on this?
Sure.
I think this is just profoundly important, maybe one of the most important constitutional issues of our time. The old religious liberty cases, the doctrinal cases, they were focused on statutes, right? And so in Employment Division versus Smith, Scalia says, listen, we have a legislative process where people can deliberate and compromise and moderate, and that is itself a protection of religious liberty. It's not a coincidence that the religious liberty issues are all arising in administrative context now, right? Because these agencies at the federal and state level, delegated big powers from Congress or from state legislatures, they just run sort of unilaterally. There isn't that check and balance of a legislative process. And it's complicated even more by the fact that so much of modern administration gets filtered through or administrated through the private sector, right? In Obamacare and so on. And so this whole new generation of religious liberty arguments or religious liberty disputes, these encroachments on religious liberty they're arising in a profoundly different context. And I think that as the courts grapple with this, they really need to keep that front and center in mind, that all those auxiliary precautions that Scalia had in mind in Employment Division versus Smith, they just don't apply anymore in the same way. And it fundamentally reshapes both the cases at hand and the importance of things like the Religious Freedom Restoration Act.
We have Evan Bolick with our next question. Evan asks, the Roberts decision in the DACA case suggested that administrations need to consider substantial reliance in order to repeal an executive order. Was that a game changer or more of a one-off, fact-specific decision? Will it make it more difficult to repeal executive orders for Biden?
Maybe I'll take that. I think it wasn't a total game changer. I think it's important. The court has alluded to this in the past in a case called FCC versus Fox, which involved agency flip-flops. The court said, we're going to give less deference to agency interpretive changes that affect reliance interests. I mean, in the DACA case, the reliance interest was particularly salient, right? So many people with so much at stake in the DACA policies. I mean, the Obama administration had sort of said, listen, these don't create rights. That's why we're not going through notice and comment. And so I guess in many ways, the public shouldn't have relied on DACA, but they did, and they were encouraged to. I think this is actually key to Roberts' thought on administration. Again, I think so much of his work over the last few years, beginning in the Obama years and through the Trump years, and I think to the Biden years, is about this unsteadiness of administration and the way that you just can't, it's no way to govern a country when so much is changing so quickly from one administration to the next. And I do think Roberts is going to continue to push on this, and I'll be interested to see how much other justices pick up on it. Although Gorsuch, too, in his 10th Circuit opinions, you know, his arguments about delegation and deference were often couched in terms of reliance. I mean, those were immigration cases, too, by the way. And so I think it's a salient concern for him as well. Yeah,
I'll add that it's worrisome as an interpretive technique, just because I think it creates really bad incentives in the executive. Think in this case, for example, where you've got Obama initially saying, I actually have no authority to do this, and then doing it. And if you know that by doing it, the more people you can get to rely on it, the more likely, the stronger your case is in the future. It gives you an incentive to use all of those people as effectively pawns in your attempt to change through executive fiat the immigration law. That is not a humane way to treat people, and it puts the judges in a more difficult position then, because then they're like, well, someone's got to call their bluff effectively. That's not. I think it encourages the abuse of different actors in every different field that way. And I also will point out that reliance interests. It's a frustrating kind of thing that often gets thrown into multi-factor analyses, and I think also in many cases gets treated very differently by different judges. So it's not, I don't think it's something you can easily say, well, are there or aren't there reliance interests? Because you've got people saying all sorts of things. You have judges arguing, that, for example, the abortion precedent has created reliance interest, despite the fact that, no one 9 months maybe worth of people could be potentially getting pregnant because of their reliance on abortion law. But they're arguing in so many different very extended ways. So it's going to be interesting to see if that really takes hold. But I think it would be a slightly pernicious addition to the law if it did, because it is so hard to it's not an objective thing to pin down. It's hard to balance, and it creates bad incentives.
It also, I'll say, creates a first mover advantage for like the regulatory administration, right? I mean, the ultimate reliance interest is on freedom and tradition before the laws are passed in the first place. And the court has never phrased reliance interest really in those terms. It's always people relying on the regulatory program. And so in a way, if this is going to stick, it means that in the future, Republican administrations are going to have to sort of go through a regulatory process to declare why they're not regulating and telling people to rely on the absence of regulation. And so to the extent that this reliance interest sticks, I think it really is incumbent upon the judges and the lawyers and the scholars to focus on reliance on the original status quo ante and not just on whoever happens to regulate first, because that's almost always going to be Democrats.
Yeah, and actually it also tends to put them on the scale of the reliance of larger industries and corporations, actually, rather than the individual. In the DACA case, I think it was, it's a different thing, because there it's clearly individuals. But in the general sense, the people and entities who know what the regulations are, almost exclusively those who are heavily regulated. The average American, I think, probably does operate with the presumption that they're probably have a freedom here to do things. They're not aware of the thousands, millions of pages in the Federal Register out there. So the only people who really are in reliance are those who can afford the big time lobbyists. I think if anything, we should argue that it's that other default reliance that should get the thumb on the scale.
That's well put. I think Randy Barnett and his presumption of liberty just got a plug without necessarily being brought up and named. Carrie, Adam, thank you so much for joining us. This was a real treat and just a fantastic way for us to start our series of webinars with the onset of a new administration. For all of our attendees, thank you for joining us today. We will have another webinar coming up in less than a week on Tuesday, January 19th. You're invited to join us for a discussion about Congress and policy and a conservative agenda going forward with Rachel Bovard of the Conservative Partnership Institute and Terry Schilling of the American Principles Project. So we look forward to seeing you then. Again, Adam and Carrie, on behalf of everyone at the James Wilson Institute, these were just fantastic bits, and we're just so pleased to be able to bring you together. And here's to when we can get together in person so you could hear the thunderous applause from a full room, which you so deserve.
Thanks, Garrett. It's a pleasure.
Thank you all.